Dear colleagues, I'm Professor Eduard Ivanov, frequent lecturer at the International Anti-Corruption Academy in Luxembourg, Austria. The International Anti-Corruption Academy is an intergovernmental organization subject of international law and at the same time an educational institution. The Academy provides technical assistance, open and tailor-made trainings for anti-corruption professionals from public and private sector from all over the world. The IACA's academic team also conducts research on compliance, anti-corruption and collective action initiatives. Today, I have a pleasure to introduce you the first IACA's online course on the use of anti-corruption compliance standards and guidelines for designing and implementing an anti-corruption compliance program. The background of this course is a comparative study conducted by the IACA's research and academic team as a part of a project implemented in the frame of the Siemens Integrity Initiative. During this study, we realized that there is more than 30 standards and guidelines that companies may consider when they design and implement compliance programs. The idea of this course is to support companies, especially SMEs, and collective action initiatives in designing and implementing compliance programs. This course consists of 4 parts. Today, I will provide you with a general overview of international anti-corruption compliance standards and guidelines. In the next lessons, we will discuss how to use these standards and guidelines for risk assessment, for defining applicable laws, for defining corporate principles and values, and finally, for designing and implementing anti-corruption compliance programs of your companies. Let me start my first lecture with a very general comparative analysis. I spent more than 7 years of my life working in the field of anti-money laundering. And usually I like to compare approaches of regulators to anti-money laundering and anti-corruption compliance. The global anti-money laundering system is based on a classical model of legal regulation. Comprehensive conventions, and especially the Financial Action Task Force standards, define in details all the formal requirements to anti-money laundering compliance programs. The international rules are implemented in national laws and regulations. Therefore, financial institutions and designated non-financial businesses and professions know very well how to design and implement anti-money laundering compliance programs. They know what are the expectations of regulators. They know how to mitigate their risks. The situation in the field of anti-corruption compliance is different. The UN Convention Against Corruption contains general provisions on public-private partnership and cooperation. No one of existing international standards and guidelines on anti-corruption compliance became a global recognition, comparable with the recognition of the FATF standards. Only few countries in the world adopted domestic laws, guidelines, or standards on anti-corruption compliance to help companies to design and implement compliance programs. Obvious question arises: how should companies design and implement anti-corruption compliance programs? Which sources of information, which sources of law they should use? Many of them use non-binding international standards and guidelines. Many of them also consider foreign laws that have extraterritorial reach, such as the FCPA or the UK Bribery Act. Medium-sized and small enterprises also take into consideration compliance programs of multinational enterprises, their business partners. Of course, for a large enterprise, it's not a big deal to hire expensive lawyers or consultants, and they will do the job. Situation with a small or middle-sized enterprise looks completely different. Many of them have just one compliance officer who is responsible for designing, implementing, and maintaining an anti-corruption compliance program. How this compliance officer should navigate to the ocean of numerous international standards and guidelines. It's not an easy exercise. And we decided to conduct comparative analysis of existing anti-corruption compliance standards and guidelines, and to produce several online courses to support SMEs in the process of designing and implementing anti-corruption compliance programs. In our study, we analyzed existing anti-corruption compliance standards and guidelines and divided them into several groups: international and domestic standards and guidelines, standards and guidelines adopted by various stakeholders, general and specific standards and guidelines. General standards and guidelines cover all the elements of an anti-corruption compliance program. Specific standards and guidelines cover just particular elements, such as due diligence or third-party risk management. We also identified standards and guidelines on anti-corruption and anti-bribery compliance, and specific standards and guidelines for small and medium-sized enterprises. I analyzed 32 international standards and guidelines on anti-corruption compliance published by various stakeholders. I cannot say that you should simply take one of them to develop your compliance program. They are very good and useful ideas in many international standards and guidelines. Perhaps one standard or guide is more important than others. There are 17 standards and guidelines published by intergovernmental organizations and bodies: the NDC, the UN Global Compact, the OECD, the OSCE, the World Bank Group, the FATF, the G20, and the APEC. I wouldn't say that, for example, the OECD guidelines are more important than the NDC guide. There is no any hierarchical system of international anti-corruption compliance standards and guidelines. We should also consider four guidelines developed by international non-governmental organizations: the International Organization for Standardization, Transparency International, and the World Economic Forum, including the very well-known ISO standard Anti-Bribery Management System. There are also 7 important standards and guidelines published by international business associations. 6 of them were published by the International Chamber of Commerce, and one by the very well-known international standard setter, the Wolfsberg Group. The Wolfsberg Group is very well known in the field of anti-money laundering. This group published numerous guidelines on anti-money laundering compliance. In 2017, the Wolfsberg Group published guidelines for financial institutions on anti-corruption compliance. But I believe that these guidelines can be also helpful for non-financial institutions in designing and implementing anti-corruption compliance programs. Finally, we consider 4 guidelines developed by a private company now Explore. Of course, we don't compare guidelines published by the private company with guidelines published by international intergovernmental organizations. But some provisions of these guidelines can be very helpful to cover particular gaps in existing international standards and guidelines. There are 12 general international standards and guidelines that cover all the main elements of an anti-corruption compliance program, and 20 specific standards and guidelines. There are also standards and guidelines on anti-corruption and anti-bribery compliance. All of you know that bribery is just one of numerous corruption offenses. In this regard, most of the existing standards use the term anti-corruption. However, 4 of them use the term anti-bribery, including the ISO standard. Probably some of you will be surprised, but only 3 standards and guides consider specific needs and realities of small and medium-sized enterprises. In 2013, the UNODC published a practical guide, an anti-corruption ethics and compliance program for business. And in this guide, there are special provisions for SMEs after each chapter. There are also the OECD guidance on anti-bribery policy and compliance for African companies, and the International Chamber of Commerce guide, anti-corruption third-party due diligence, specifically published for small and medium-sized enterprises. I would like to mention that the OECD guide was published for African companies, but it could be also a useful source of information for small and medium-sized enterprises from other continents. At the beginning of my lecture, I have mentioned FATF as a global regulator in the field of anti-money laundering. It's interesting that the FATF also published several documents that can be very helpful for designing and implementing an anti-corruption compliance program. You may ask why the FATF is so important regulator. Initially, in 1990, the FATF published recommendations on anti-money laundering that were nothing else than recommendations. Nowadays, 204 states and territories recognized the FATF standards as global international standards in the field of anti-money laundering and implemented these standards in national laws and regulations. The UN Security Council calls all the states to implement the FATF standards in the resolutions adopted in accordance with the Chapter 7 of the UN Charter. The FATF has a very effective mutual relations system. Of course, the FATF is not the UN Security Council. The FATF may not decide to apply the sanctions against the FATF member states for non-compliance or non-implementation. At the same time, the FATF has an opportunity to call all the FATF member states to apply sanctions or to apply enhanced due diligence or other measures against the states for non-compliance and non-implementation. And I would say that this practice is very effective. In my personal opinion, the FATF standards became already international customary law. The FATF is responsible for combating money laundering, financing of terrorism and proliferation. Anti-corruption was not specifically mentioned as a key function of this international body. However, the previous FATF mandate and the new FATF mandate adopted in 2019 mentioned as one of the functions of the FATF preparing guidance as needed to facilitate implementation of relevant international obligations in a manner compatible with the FATF standards, including developing special measures to prevent misuse of the financial system relating to corruption. International standards on combating money laundering, the financing of terrorism and proliferation can be useful both for anti-money laundering and anti-corruption compliance. The FATF also published guidance on politically exposed persons and transparency and beneficial ownership. To support the use of the FATF documents, the FATF published best practice paper, the use of the FATF recommendations to combat corruption. Besides of this, the FATF reports on typologies of money laundering related to corruption offenses, for example embezzlement of public funds, can be also useful for designing an anti-corruption compliance program. For example, for drafting particular policies on due diligence and risk management. Besides of the international standards and guidelines, companies can, or sometimes even shall, consider guidance published by governmental authorities in some countries. Domestic guidelines on anti-corruption compliance were published in Brazil, Italy, France, Russia, Ukraine, the United Kingdom, and in the United States. Several countries also recommended domestic companies to use the ISO standard anti-bribery management system. The UK Bribery Act and the US Foreign Corrupt Practices Act laws that have so-called transnational application or extraterritorial application. It means that these laws may be applied to foreign companies that have committed corruption offenses outside of state territories of the United Kingdom or the United States, and also to the employees of these companies in some cases. In this regard, many companies from different jurisdictions consider guidance published by the UK Minister of Justice, by the US Securities and Exchange Commission and the US Department of Justice when they design and implement anti-corruption compliance programs. One more point. Quite often, companies that are legally obliged to comply with the FCPA or the UK Bribery Act would like to mitigate their risks when they do business with third parties. They apply special anti-corruption clauses to contracts and establish contractual obligations of their business partners to consider the provisions of the UK Bribery Act or of the FCPA and guidelines published by the UK or by the US authorities. Even if your company is not legally obliged to comply with the US or the UK anti-corruption law, I would recommend you to read and properly consider guidelines published by the US or UK authorities, because they are very well developed. I would also suggest you to consider guidance published by the French Anti-Corruption Authority. Many elements of an anti-corruption compliance program, for example, code of conduct or conflict of interest, are very well developed and described in the French guidance. As you see, there are numerous international standards and guidelines published by various stakeholders. In the next lectures, we will discuss how to use these standards and guidelines and some domestic guidance for designing and implementing an anti-corruption compliance program. I will share with you useful ideas from various standards and guidelines for each step of the developing an anti-corruption compliance program. In general, international standards and guidelines define several steps in the process of developing an anti-corruption compliance program. You should start with a risk assessment. The risk assessment is a precondition for designing an effective compliance program. The compliance program should be tailored to your realities and to the risks your company has. After that, you should define all laws applicable to your company and your corporate principles and values. These principles and values should be understandable for your employees and for your business partners. It's very important to find language that your business partners and employees will understand. And only in this case, they will support your compliance program. They will share with you your principles and values. Another important step is an assessment of available resources. You can have a brilliant compliance program on the paper, but if you don't have sufficient resources, this program will be never implemented and will never help you to protect your company from corruption risks. After that, you can start designing your compliance program. You should decide which policies do you need. For example, if your company will be never involved in the political financing, you don't need a special policy on political financing in your compliance program. The next step is drafting internal documents. And finally, you should communicate your compliance program to employees, to our business partners, and government authorities. You should make clear that your company doesn't accept corruption and will be never involved in any kind of corrupt deal. You can find useful information in the overview of anti-corruption compliance standards and guidelines published by the International Anti-Corruption Academy. This publication is available on the IACA website. Dear colleagues, next week we will discuss a risk assessment. I will share with you the most useful recommendations of the anti-corruption compliance standards and guidelines and best practices. We would also appreciate your feedback. If you have questions, comments, maybe ideas on new trainings, or even proposals for cooperation, please don't hesitate to contact the International Anti-Corruption Academy via email onlinetraining@ayaca.int. Thank you very much for your attention.